Well, let's discuss this now, and we're joined by Independent Electoral Commission's Granville Abrahams. Mr. Abrahams, good evening to you, and thank you for your time. So, 42 candidates appearing on more than one party list, and how many parties are implicated here?
Yes, thank you very much. We are required, first and foremost, in terms of the legislation, there's nothing untoward about this, but we are required to notify parties where this occurs. The 40-odd duplicates that we have come from about 30-odd parties. So it's not in terms of the bigger scheme of things, in terms of the number of candidates, it's actually not a high occurrence in terms of if we need to compare this to local government election, where obviously there are much more seats and the occurrence is very high. So nothing really untoward about this. It's just procedural, and in terms of the legislation, we have to inform both parties, or in the case of an independent as well. There may be instances where a candidate has been placed on a party's list, and the candidate may then argue and say, I did not actually sign an acceptance of nomination. So the fact that my name appears on more than one list does not necessarily mean that I agreed to that. So we are finalizing that. But where a response is not received, that anomaly will remain. The candidate will appear on both lists, both parties.
That's very interesting. Let me begin with what you are saying, that there is nothing untoward. Are you finding in most of these cases, these 42 cases, that this is deliberate action on the part of the candidate themselves, or is it a pure mistake by political parties themselves?
Well, first of all, I think it's a surprise to the parties because we've had response in most of the cases where parties have now said, well, if this is the case, I am replacing, and they have an opportunity in this window to replace that candidate with someone else, or simply just to delete him. And parties have made use of that opportunity. Alternatively, a candidate may come up in his defense and say, I've been incorrectly added to that list. I have not agreed to any of this. And in a case like that, to settle that dispute, we will request the actual acceptance of nomination from the party that the candidate alleges he did not sign with.
You are calling it an anomaly. I'd like to ask the question, if indeed it does appear that someone may have put themselves on more than one party list, would that constitute electoral fraud?
No, not at all. Not at all. There is nothing preventing that, but as I've mentioned, in the legislation, and it was for local government the same, since I think 2016, parties have asked for this to be included in the legislation, just to be notified. And in most cases, by the time we get to the ballot, this is resolved. As I said, either by the party removing the person, or alternatively, the candidate stating that he did not sign up, and the party who have added them to that list not being able to provide an acceptance of nomination. Now, if it comes to the issue of fraud, the candidate obviously has the opportunity to open up a docket if he is of the view that he did not sign an acceptance of nomination and his name was placed on a list irregularly. Yeah. But that is up to the candidate at the end of the day.
Well, talking about potential court cases, let me quickly latch on to what happened today. But I want to throw forward to the case that is actually still going to be heard. So the ANC challenging the use of the name Umkhonto weSizwe, it says that this is the property of the ANC. If the Umkhonto weSizwe party were to lose that matter in court, what would the implications be?
Well, I think the issue at stake in the court this time around is the issue about the trademark name, etc. Mm-hmm. If that is the case, then obviously depending on what the judgment or the order states. But in worst case scenario, it would mean that the party would not be able to contest under that name. The party would, however, be able to go through the procedure, but time is obviously not on our side to apply for a name change and a logo change. And unless the court assists us in this matter, we may end up in a situation where we have a party that has complied with the candidate nomination procedure, mm-hmm. but is forced to desist from operating under a specific name and or logo, whatever the case may be. So we're hoping that the courts may assist us in this matter.
Sure. Just out of interest, if indeed that becomes the scenario, how much time would the MK party, if it were to lose this case about the name, how much time would it have to change both the name and logo?
Well, first, the normal procedure, and as I said, I hope that hopefully, depending on what the outcome is, and if there is a situation that would require attention, hopefully the courts will assist us in this matter. The normal procedure is that if a party wants to change its name or its logo, it has to, in this case, advertise in the government gazette, and I think that only comes out on a Friday. And then the IEC can only attend to that request for a name change or logo change after 14 days have passed. And the 14 days is basically to allow for any objections to reach the chief electoral officer at the same time.
Yeah.
So the chief electoral officer would consider the name change and or logo change together with any objections if received. So that would only be after 14 days after having been published.
Very quickly, sir, last issue. The Democratic Alliance has taken you to court demanding more voting stations for South Africans living overseas. What's your defense in that matter?
Well, we are guided first and foremost by DIRCO, the Department of International Relations and Cooperation. The IEC does not operate in its own right outside of the borders of the country. We have no right to do that. So we work within the protocols of the Department of International Relations and Cooperation. And the view there is that we only have, I think it's about 115 or close to that, recognized and fully operational either embassy or high commission in some places in the Commonwealth as it's known, or a subsidiary consulate to those missions. We are therefore not at liberty in terms of international relations, as we are advised by DIRCO to go and open up voting places. It's not our country anywhere other than in our space. And our space defined in terms of protocols and the Vienna Convention is within embassies and the official missions. So that's basically our position that we are guided with by the Department of International Relations and Cooperation.
Granville Williams, let me thank you very much for your time, IEC General Manager for Electoral Operation.